As I understand it, the only reason you have a Bill of Rights in the United States is that not all states would join the Union. Once the Constitution was agreed, there were still states who held out because they didn't trust this new federal instrumentality, which they thought might develop into something again like being in the empire, some control which they didn't want. So there are the Bill of Rights. Has this been of advantage to the United States?
I think absolutely. I think that one of the things that in studying the Australian Constitution that's clearly evident is you can go through chapter by chapter and you can identify the lessons learned from the American Constitution. And Marbury versus Madison is one of those that's very clear.
One of the problems with the American Bill of Rights, as I see it, is that their interpretation is left to the Supreme Court. Judges on the Supreme Court are appointed for life. Mm-hmm. And if a judge decides that he or she wants the Constitution to mean what he or she wants it to mean, that will occur. So you get interpretations of the Bill of Rights which were certainly not the original intention. Now, the Bill of Rights, those clauses of the Bill of Rights are taken essentially from the English Bill of Rights. The English Bill of Rights was the way in which the monarchy became a constitutional monarchy in 1688. Not our form of constitutional monarchy, it was an executive constitutional monarchy, the king retaining real executive powers, but agreeing to subject himself to the Parliament in relation to legislation. And you had William and Mary coming across, and it was a condition. It was a revolution. The king fled. William had invaded England. James left England, threw the Great Seal into the Thames as he left, which they said constituted an abdication. The House of Lords said he's abdicated the throne is vacant, and they chose his daughter, thus avoiding the rule that the first male would succeed, and her husband, who was the Dutch stadtholder, William. So you really got a revolution. It's called the Glorious Revolution, and it established the constitutional monarchy. But to accept the throne, they had to agree to the Petition of Right, the Bill of Rights, which sets out all the rights which you find, and many more, which you find in the American bill, including the right to bear arms. But the right to bear arms was only for Protestants, curiously not for Catholics, because James was a Catholic, and James was seen to be copying the Catholic King of France and introducing an absolute monarchy into England. So Catholicism was not thought of as appropriate in that it was essentially also a Protestant revolution, because James was a Catholic. So, but you think that the Bill of Rights, as it is interpreted, is a good thing?
Well, a couple of things on that. First of all, as I mentioned earlier, I think freedom of speech is one of those that, and there's a reason it's first. That's in the First Amendment, and we don't even have
with freedom of religion.
Yes, exactly, with 5 others.
But that's incorporated into the First Amendment.
Exactly. But we don't even have freedom of speech codified into law here. There's some things about libel, and there's some things about political speech and so on. But we don't, there's some precedents that have been set, but we don't have that right given by our Constitution. But the other point I was going to make earlier is that the Bill of Rights isn't that long. The American Constitution isn't that long. But if you look at the Australian Constitution, it's much more detailed and goes into much more, elaborates much more on many of these points. And because the American Constitution and Bill of Rights are so short, without a lot of elaboration, it leaves it open to interpretation, which was your earlier question. And you've got strict constructionists who think, like Clarence Thomas, who says, the Constitution does not mention school buses, and so school busing should not be a constitutional issue for us. And you have other people other justices, who think that it's a living document and it's 250 years old and it needs to evolve and needs to be interpreted based on the context of the time. So, I think that you're always going to have it, when it's not spelled out clearly in America, in the American Constitution, you're going to have those interpretations. Whether that's a good thing or a bad thing, I think we could argue, equally, we could argue both sides of that. But the fact is, it creates, it creates a situation where you're going to have conflict between those justices, the constructionists and the more progressive thinkers.
And a president has no idea how a judicial appointment is going to turn out. Famously, at the end of his period in office, President Eisenhower was asked about the good things he achieved during his period in office. And he's also then asked, what were the worst things in your period in office? And he said, worst things? He said, they're both sitting on the Supreme Court. He appointed 2 judges. They were what he thought were good lawyers, conservative lawyers. They became 2 of the most radical lawyers that the Supreme Court has ever known. And he was very surprised by that. But if the judges are controlled by the people, as you and I agree, that would control excesses by judicial excesses, would it not?
It would. The problem, I think, comes down to figures that are not necessarily well known. In the state of California, we vote for county judges. But I don't think anybody has any idea who any of them are. It's just a list of names. And even, I've done research before trying to find out, who is the best candidate. And it's difficult. So I think, in a very high profile appointment, like to the Supreme Court, for example, there would be much more information and case history and all those kinds of things.
I wasn't proposing election of judges. I was talking about
I thought you were.
A review by the people, the right to initiate reviews of decisions. When the judges of the Supreme Court in America or the High Court in Australia declare a principle, which is really a major piece of legislation. For example, before the Civil War, when they declared that slavery was protected by the Constitution. There's nothing in the Constitution which says that. Or when they decided after the Civil War in Plessy and Ferguson that segregation was authorized by the Constitution, notwithstanding the amendments following the Civil War. Or when they decided in Roe v. Wade that the Constitution provided a constitutional right, not a legal right which would be given under state law, but the Constitution provided a constitutional right to abortion. Or when the Australian High Court decided that people who were living with Indigenous people but weren't Indigenous, who were born outside of Australia, were protected and therefore could not be deported if they committed violent criminal acts. These are all things which seem surprising when they are declared, and perhaps the answer to having a group of people suddenly deciding something which surprises everybody is to allow the people the final say as to whether that should be retained or whether it should be changed.
What is the situation in Switzerland? Are they able to review judicial appointments? Not judicial appointments, judicial decisions?
The Swiss constitution goes one step further. The Swiss Supreme Court is forbidden from interpreting the Constitution. It's a matter for the people. The people make decisions and they can change the Constitution if they wish. So the Supreme Court makes decisions about criminal trials and rights to water and all sorts of disputes, but it doesn't interpret the Constitution.
Interesting.
Which is an interesting provision.
It is, very.
Which would astound their honours in Washington. But do you think that the Bill of Rights, there is an advantage in having a Bill of Rights in the Constitution?
Well, and whether it's in the Constitution or whether it's codified by law, I think it's important. I don't know if is there a difference if it was codified in federal law somehow versus being part of the Constitution?
Well, that's an interesting question. And in fact, this I think really brings us to an end on the general matter of the Bill of Rights.